3, 2, 1, start. The petitioner duly replied to the said inquiry report through a representation dated 30th June, 2004 and subsequent thereto, the petitioner was issued a second so-cause notice dated 10th July, 2004 to which the petitioner replied on 27/07/2004 and the final order of punishment was passed vide memorandum dated 12th August, 2004 issued by the respondent number 4 imposing a punishment of reduction of 2 increments in his existing scale with cumulative effect. Stop para. Aggrieved by the said order of punishment, the petitioner preferred a statutory appeal, but the same was dismissed by the appellate authority vide memorandum dated 26th April, 2005 upholding the order of punishment. Stop para. Mr. Shorthand Dotto, learned senior advocate appearing on behalf of the petitioner submits that the respondent number 4 did not consider the petitioner's reply to the so-cause notice and issued a charge sheet which is a replica of the so-cause notice, and that the said charge sheet does not contain any imputation pertaining to the alleged charges, and the list of documents and the list of witnesses were also not disclosed by the disciplinary authority. Stop para. Mr. Dotto submits that in the charge sheet there was no specific charge to the effect that the petitioner had taken 16 months time to replace his own meter and that such action on the part of the petitioner was an act of misconduct. Stop para. Mr. Dotto had further argued that the petitioner had explained the allegation of 16 months delay towards replacement of the meter by stating that there was a shortfall in supply of single phase meter for domestic consumers and that the shortage during the particular period was 37%, and that by considering the revenue recovery for both benefit and for giving service to the consumers, a priority was accorded, as a matter of policy, to utilize the meters available for the needs of the consumers, and that such action on the part of the petitioner cannot be said to be a misconduct, and furthermore the respondents did not suffer any pecuniary loss for such alleged delay towards replacement of meter by the petitioner. Stop para. Mr. Dotto further submits that the inquiry was hurriedly concluded in a mechanical manner by fixing 2 dates of hearing on 21st January, 2004 and 23rd March, 2004, and that in the said inquiry the presenting officer did not produce any witness, and that the blue card and the yellow card, which were respectively marked as Exhibit A and Exhibit B, were also not corroborated through any evidence. Stop para. Mr. Dotto further submitted that the documents produced by the petitioner through the written argument were also not considered by the inquiry officer, and the inquiry was abruptly concluded through filing of a report on 31st May, 2004. Stop para. As regards the said inquiry report, Mr. Dotto submitted that even after arriving at a conclusion to the effect that the charge towards enjoyment of electricity with low consumption could not be proved against the petitioner, the inquiry officer observed that the petitioner had taken 16 months time to replace his own meter, and that such type of irregularity was unbecoming of the petitioner being the station in charge. Stop. The reply to the inquiry report was submitted by the petitioner on 30/06/2004, but according to Mr. Dotto, there is no reflection in the second so-cause notice that the same was considered by the disciplinary authority. Stop para. According to Mr. Dotto, the detailed reply filed by the petitioner to the second so-cause notice was also not considered by the respondent number 4, and the final order of punishment dated 12th August, 2004 reflects no independent application of mind on the part of the respondent number 4. Mr. Dotto also points out that the irregularities and the charges as featuring in the so-cause notice and the charge sheet respectively do not tally with the charges incorporated in the second so-cause notice and the final order of punishment, which began through incorporation of a paragraph as follows: :para. By the charge sheet, issued under memo number PD/493 03/530 dated 22nd/04/2003, the following charges, in brief, level against Jagannath Adhikari, para 1. The charged employee being a station in charge was taken 16 months time to replace his own meter. Stop. On 30/09/2000 the meter was declared stop and sticky, whereas on 6/2/2002 the meter was replaced. Stop. Para 2. During the period from 01/01/2001 to 05/02/2002, average 40 units were charged against the service connection of Sri Jagannath Adhikari. Stop. Supplementary bills have been raised for the last 6 months before 06/02/2002 at the rate of 20 units per month only. Stop. Thus Sri Adhikari, being the station in charge, was enjoying electricity on low consumption. Stop. Para. Mr. Dotto further submits that a perusal of the second so-cause notice and the final order of punishment would reveal that the contents of the same are identical, which supports the contention of the petitioner to the effect that there had been no independent application of mind on the part of the respondent number 4 and no consideration of the reply to the second so cause notice and the impugned order of punishment had been issued mechanically. Stop para. Mr. Dotto further submits that the appellate authority had proceeded on the basis that the petitioner effected a service connection in his name and took 16 months to replace his stop and sticky meter and availed undue benefit of enjoying low consumption by raising average bill during the period of stop meter. Stop.